Okay, thank you so much. Again, I want to thank the National Constitution Center and Jeff Rosen for this opportunity to do this symposium on the Declaration of Independence as a constitutional document during the early republic and thereafter. I'm just waiting for my slides to come on, and then we'll begin. Great. All right. From the time of its signing on July 4th, 1776, the Declaration of Independence set the mandate for constitutional governance. I say mandate because not as an aspiration, but in my opinion, as an actual obligation on government. Even after the ratification of the Constitution, the Declaration continued to set the norm for the exercise of legislative, executive, and judicial functions. After the Civil War, the country made its commitment to the norm even more clear by the ratification of the Reconstruction amendments. For over 2 centuries, the American people have regarded the Declaration of Independence to be a foundational statement of American constitutionalism. What's more, our understanding of the Declaration's message is not static. It is, rather, the product of centuries of reinterpretation by various social movements. Memorable phrases about the inalienable rights of life, liberty, and the pursuit of happiness, safety, and the course of human events have established a collective consciousness for discourse. We heard Mark Graber speaking earlier how different groups can take on the Declaration in their arguments, and that is exactly its function. It is meant as a document, both for liberals and conservatives, to make arguments. It is a discursive position that if one deviates from, then one has gone outside the bounds of legitimate constitutional discourse. The great Samuel Adams, while serving as the acting governor of Massachusetts, told his state assembly that when, and I quote now, the representatives of the United States of America agreed, now this is Samuel Adams speaking, trying to figure out the extent to which the Declaration influenced the founding generation. All men are created equal and are endowed by their Creator by certain unalienable rights. They proclaimed the doctrine of liberty and equality to be, and continuing in Adams's words, the political creed of the United States. For him and the statesmen of Massachusetts, the Declaration of Independence was not an obscure document. The Declaration of Independence readily became part of the collective American conscience because Thomas Jefferson had tapped into what was the contemporary thought of the day. Boy, I'm kind of skipping ahead here with a bunch of stuff, aren't I? However, these great ideals mattered much more in principle than they did in practice, because Jefferson, as we all know, remained a slave owner throughout the course of his life. Others were far more true to the ideals of the Declaration than its author. For instance, a speaker in the 1800 4th of July celebration rejoiced at the revolution of freedom, but she bewailed that those who were in power only applied the phrase, all men are created equal, to half the people. The Declaration's statement of liberal equality, she asserted, this is again 1800 4th of July, must apply to all humanity, male and female. She also mourned for the fate of Africans, which had suffered murders, robberies, and burnings, as she said, and the punishment of endless slavery in the United States. Declaration of Independence, she exclaimed, where art thou now? The Declaration by that point had already influenced great thinkers of the day. Contrary to the hopes of prominent revolutionaries like Benjamin Rush and John Jay, adoption of the Declaration's statement of universal rights did not lead to slavery's immediate demise. The widespread, the framers needed only to proclaim an independence. They only needed national sovereignty. They didn't need any more. In fact, they had done just that on July the 2nd. Our date of independence is July the 2nd. That's when we became independent of Great Britain. But they did so much more, far more than Latin American countries that followed, except for Haiti, none of whom had our preamble, but solely expressed the purpose of sovereignty and the evils that colonial powers had done to them. In recent years, several books on the Declaration of Independence have mistakenly asserted that the document had virtually no influence on American politics until the War of 1812. You heard Jack Rakoff take a very similar position. This historical error is based on a 1962 article by Philip Detweiler, who wrote a wonderful, in-depth study, but he had very limited resources. Succeeding historians like Pauline Maier and David Armitage have accepted Detweiler's claim without following up with their own archival and primary source research on the subject. In the day and age of computer research, it's clear that Detweiler had overstated his findings, but his thesis continues to be the mainstay amongst historians. And this is primarily the subject of my talk this afternoon. I think if you have a chance to take a look at my book, For Liberty and Equality, you'll find that the Declaration revolutionaries in the immediate period, 1776 on, with lapses periodically, was not thought of as just a statement of sovereignty, but rather as a statement of human rights. Ordinary people and public speakers understood from the get-go that the Declaration was a mandate for a representative government to protect inalienable rights. The proof is there from the get-go. Rather than simply announce independence, we have this statement of purpose just 2 days after it. That's Congress immediately directed the publication of the text. The Dunlap broadside was typeset on July 4th so that all could read it, and the next day, John Hancock dispatched it for reading in the States, and the document was widely republished. Here by Dunlap himself, right here we have the actual broadside, and here we have it in Dunlap's publication, as well as throughout different states. That's just one example. There are many, many examples that we can bring in. This one from the New York Journal. And the document was read widely because, of course, at that time, in the day, that was the way that people got their political news. The text of the Declaration was also read throughout the 13 states to inform people of the universal principles to which the nation was committed. It was first read publicly on the 8th of July, 1776. Now, I'm trying to gauge the extent to which the Declaration's principles were known immediately. Of course, in Philadelphia, where it was first read, is where the Continental Congress was meeting. The honor fell on Colonel John Dixon, a sheriff and a member of the Council of Safety. He later became the president of the Bank of North America, which was the precursor of the Bank of the United States. Nixon read the document to loud applause at the State House yard, nearby from where we gather today, and it later was renamed, as we know, Independence Square. The first copy of the Declaration was also fastened to a pole for public display. The document was likewise read throughout the other states to both civilians and soldiers. The message was as much a call to arms as it was a statement of national purpose. You heard Jack Rakoff, who said it was just a document that kind of fell off, but it was read throughout the states in many, many cities. Because of its close proximity to Philadelphia, the inhabitants of Dover, Delaware, received word of the achievement by post on July 5th and 6th to loud huzzas and much approval. The first reading of the Declaration of Independence in New Jersey took place on July 8th in Trenton, to great rejoicing. News traveled like wildfire to other parts of the state, indicating the revolution enjoyed widespread support. Frolickers in Bridgetown, New Jersey, burnt the king's coat of arms as they had earlier here in Philadelphia. Those in attendance in New Jersey then heard a speech from a renowned physician from West Jersey who solemnly proclaimed that they were entering a great but terrible period and adjured the audience against using their new freedom as an excuse for disorder and licentiousness. On the 9th, the Provincial Congress of New York, meeting at White Plains, approved of the Declaration of Independence and changed its name to the Convention of Representatives for the State of New York. In other words, there was first a proclamation by the people of independence before New York even changed its name to a specific name that had to do with a state, as opposed to a colony. 3 days later, a soldier stationed in New York, he was a private, wrote to his father, "I must heartily congratulate you for the Declaration of Independence, a declaration which happily dissolves our connection to the kingdom where the name of the king is synonymous to that of tyrant and the name of subjects to that of slaves." Remarkable in this report is not only the zeal of the soldier, but the extent to which it melds with faith of the revolution as a means for liberation. Not simply sovereignty, not simply as a statement of giving power to the states. For many, however, liberty remained no more than a byword. On August the 8th, 1776, I don't have this slide because it would be difficult to read and it would take 2 slides. The New York Journal, this is August 8th, 1776, reported a reading of the Declaration of Independence where toasts were raised to the liberty to those who have spirit to assert it. Advertisement in the same issue starkly showed how narrowly some understood this word. So there's celebration written about on page 1. Later on, I believe on page 4, John Mitchell offered a reward for the capturing of a runaway mulatto slave named David. Benjamin Pitney offered a reward on the same page for the capture of a Negro man named Samson. And Jacob Wilkins advertised to pay for the capture of a Negro man named Jack, who was born in Guinea and spoke broken English. Of the New England states, reading the Declaration in Massachusetts appears to have taken place first in the city of Worcester on the great and near the Liberty Pole. It was a sign of liberty. After reading the Declaration in Boston, toasts were raised. Among them, prosperity and perpetuity to the United States of America. Another toast was offered for the underlying aspiration of the revolution to attain the universal prevalence of civil and religious liberty, long before the First Amendment and long before 1787 with the Constitutional Convention. Rhode Island, always one of the most progressive colonies, after the public reading of the Declaration on July 26, celebrants not only toasted the 13 states, a participant also lionized the international implications of liberation. May the liberty expand her sacred wings and in the glorious effort diffuse her influence o'er and o'er the globe. Thus, at a time when Americans were celebrating unity, they were also speaking in terms of human rights, not merely national sovereignty. In Providence, salutes were made for the independent states of America forever to be an asylum for liberty. Likewise, reading of the Declaration occurred in southern states, in Maryland on July 22nd, Virginia July 25th. In the Deep South, men and women of all ages gathered in Charleston, South Carolina on August 5th around the Liberty Tree to hear a reading of the Declaration. That same spot had been a revolutionary gathering place since the time of the Stamp Act protests of 1763. The beating of drums, playing of music, and the sight of waving flags added to the independence festivities. Following the document's recitation, Episcopalian Reverend William Percy delivered a patriotical address in the sweltering heat, during which a slave fanned him. A foreigner writing home of this incongruous sight could not help but notice the hypocrisy of reading of liberty while being cooled by an individual bound to perpetual slavery. A clear indication that the Declaration was conceived as a proto-constitutional statement rather than as a glinting generality is its prominent appearance prior to ratification of the United States Constitution in 1789 in publications and state statutes. So, in 1782, the Continental Congress published, this is the title of the book, The Constitutions of the Several Independent States of America, which in the next year, in 1783, was reprinted in London. Printed was the Declaration of Independence at the very front, the very first document in this tome of laws, as a statement of national legal commitment, even ahead of any state laws. The first paragraph of the Pennsylvania Declaration of Rights in the states, which was September 28, 1776, just a very short time after the Declaration was signed and was read widely, contained a clause almost identical to the second paragraph of the Declaration of Independence. You don't need to take my word for it. Thomas Paine, writing an open letter to the citizens of Pennsylvania, asserted that their 1776 Constitution, again for the state of Pennsylvania, was, quote, conformable to the Declaration of Independence. The prologue of the 1780 Massachusetts Constitution also contained a Bill of Rights drafted by John Adams, which dramatically proclaimed, I'm going to read this little bit, try to read it quickly, all people are born free and equal and have certain natural, essential, unalienable rights, among which may be reckoned the right of enjoying and defending their lives and liberties, that of acquiring, possessing, and protecting property, in fine, that of seeking and obtaining their safety and happiness. Sounds very much like the Declaration. That's 1780. Those sentiments represented a radical formula for universal equality and unalienable rights of the Declaration of Independence, in part reflecting Adams's role in editing Jefferson's first draft of the document while serving with him on the Declaration's drafting committee. In an 1841 letter published in an abolitionist paper, John Quincy Adams, who was John Adams' son and later became president after Madison, wrote, "The virtuous principle of the Revolution of American independence was human liberty, universal human liberty. This was emphatically the principle of the Declaration of Independence. It was the paramount principle of the Declaration of Rights, forming the foundation of the Constitution and Commonwealth of Massachusetts." Pennsylvania and Massachusetts are not the only examples. The New York Constitution of 1777 reduced the Declaration in its entirety within the substantive text of the document. The Acts of the Laws of the State of Connecticut of America, published in 1796, republished the Declaration of Independence immediately after the Charter of Ancient Colony of Connecticut, before the Constitution of the United States, ahead of any laws passed by the Connecticut's General Assembly. That schema of binding laws, beginning with the national laws and moving on to state authority, would not have been surprising because it was common. The laws of the state of New Jersey in 1800 differed. There, the Declaration of Independence appeared immediately after the Constitution of New Jersey. The laws of the state of New Hampshire of 1792 contained the Declaration of Independence before all state laws of any type. And the Digest of the Laws of Georgia in 1800 contained the Declaration in the same prominent place. Although most Americans who were, after all, raised in a world where women and blacks were regarded to be subordinate as a matter of nature, probably did not grasp the full implication of the Declaration's recognition that all human beings are endowed by the Creator with the same unalienable rights. Many, both in the founding generation and in the generation that followed, understood that humanitarian ideology, which was the inspiration of the revolution and was incompatible with slavery. In the late 18th century, many groups adopted the Declaration of Independence as a statement of rights, not only as a justification of independence or merely empty rhetoric, so that a writer by the name of Crito in 1787 pointed out that the proclamation that all men, that's his quote, have unalienable rights must refer to blacks as much as whites, making those who exploited them for forced labor ridiculous and wicked. I want to go back. The previous panel wasn't sure when it was that the Declaration began to be influential on the people, and I've now argued that people knew it well. It was read out loud. This originalist claim, right, seems to have people have known it quite widely distributed in the laws. Did people think it had legal effect? Pre-published in laws. What about just popular folk? In 1781, the great Quaker abolitionist Anthony Benezet wrote that the guarantees of the U.S. Creed covered all colonial inhabitants, irrespective of race and class. The Declaration's statement about the people's right to separate from Great Britain, Benezet wrote, quote, apply to human nature in general, however diversified by color and other distinctions. Even earlier, just 2 years after the Continental Congress adopted the Declaration of Independence, now 1778, Benezet already believed that its statement about all men being created equal with unalienable rights, of life, liberty, and the pursuit of happiness, placed certain moral demands on the nascent nation. The document's binding recognition of the rights and statement against political oppression were also a telling condemnation. We're telling condemnation against the slavery of Negroes. In the same year, 1778, just to get a reference point of how quickly people began thinking the Declaration had an actual effect and how quickly it changed people's lives, Jacob Green delivered a sermon in New Jersey. Like Benezet, Green expostulated about the incompatibility of the Declaration's statement of human equality and entitlement to liberty with the retention and the promotion of slavery. Understanding the Declaration was a statement of the nation's commitment to universal rights continued into the next decade. In a 2-column, side-by-side presentation, New Jersey Quaker David Cooper in 1782 drew readers' attention to the Declaration of Independence's statement of rights and obligations. While on the right-hand column he wrote, right, so he's got the Declaration on one side and then he's got a running commentary on the other side. At one point in his commentary he writes, if these solemn truths uttered at such an awful crisis are self-evident, unless we can show that the African race are not men, words can hardly express the amazement which naturally arises on reflecting that the very people who make these pompous declarations are slaveholders and by their legislative conduct tell us that these blessings were only meant for the rights of white men, not of all men. We need not adopt Tawney's view that this was the popular view, because it wasn't at the time. The thought of the Declaration was a universal view. Taking the Declaration outside the realm of religious dialogue, in a speech before the American Philosophical Society, George Buchanan quoted the document to demonstrate that its principles were incompatible with the oppression of the unfortunate Africans. These anti-slavery sentiments were by no means held by all Americans, but they demonstrate that from the time of the nation's founding, a variety of visionary thinkers regarded the Declaration of Independence to be an inspirational statement of government obligation to protect intrinsic human rights on an equal basis. And the New Jersey Society for the Promotion and the Abolition of Slavery in 1793 quoted the Declaration in its Constitution to demonstrate that the document's principles were incompatible with the oppression of Africans. This pattern carried on into the 19th century, with the American Anti-Slavery Society in 1833 proclaiming the Declaration of Independence to be the cornerstone of the Temple of Freedom. Abolitionists' devotion to the 1776 statement appears in an innumerable number of their depictions in the early 19th century. The messages of abolitionists came through in sermons, speeches, newspaper articles, books, petitions, and artistic renditions. At a time when the opponents of slavery could not turn to the Constitution for redress with the Three-Quarters Clause, Slave Importation Clause, Fugitive Slave Clause, Commerce Clause, and others, they were actually supporting slavery. Abolitionists believed the Declaration of Independence's statement of natural rights imposed a national obligation to emancipated slaves, and they counterposed this with the protection of slavery found in the U.S. Constitution. The Bill of Rights had not done away with the Three-Fifths Clause and the Fugitive Slave Clause, which supported slavery. There were simply no similar slave protections in the Declaration. The Confederacy was wrong. The abolitionists, the Declaration, for abolitionists, the Declaration was a core legal statement of inalienable human entitlements. It superseded any contrary constitutional or statutory compromises for the slave power because it was the foundation of American constitutionalism. Just to give one example of this trend, Underground Railroad conductor John Rankin lauded the Declaration's fundamental principles of republicanism, while denouncing the Constitution for giving slave states an extra congressional representative for every 70,000 slaves. The very congressman, Rankin said, who gained seats on the basis of slavery, entered political office to strengthen the yoke and tighten the chains of the cruel oppression. This denied slaves any effective representation. The principle of the Declaration of Independence were further trampled in the dust, said an original member of the Anti-Slavery Society, Robert Hall, because the Constitution's insurrection clause required the federal government to militarily suppress slave rebellion. I just want to make that a little bit clearer. They were referring not only to the second paragraph of the Declaration, but elsewhere also. And what about the pro-slavery view? You heard about that a little bit. The abolitionist view was in sharp contrast with it. By the early 1830s, and not earlier than that, I have scoured the archival record, but by the 1830s, it had become in vogue for Southerners to mock the wording of the Declaration of Independence. This was pre-Confederacy, pre-Jefferson Davis, because they were mocking the idea that there would be natural rights for universally and for blacks as well. Skepticism about the document's statements of natural rights had their origin in the Revolutionary period, but the pro-slavery argument maintained that involuntary servitude was like any other labor subordination. Slavery's apologists regarded the self-evident truths to be no more than an exaggerated statement. Just as the Declaration of Independence's maxim did not apply to differences in wealth, education, and skill, the supporters of slavery argued that it was irrelevant to the unequal treatment of blacks. South Carolina Senators John Calhoun, who became a major force in nullification leading up into the Civil War, was one of the best known and the most adamant defenders of slavery. He mocked the Declaration's claim of equality of the human races as being an error inherited from the writings of British philosophers. Others in the pro-slavery movement acknowledged the Declaration's statement of equality, but asserted it to be inapplicable to blacks. This was, for example, true of Chief Justice Taney's Dred Scott opinion, who just makes a complete anachronism, complete inaccurate, originalist argument, which some apparently have adopted and now believe. Finally, the Confederacy's president, Jefferson Davis, relied on the Declaration of Independence as a statement of state sovereignty. But if we go through the Declaration of Independence, there is nothing there on it. It's purely a statement of the people's right and a grant of sovereignty to the states. But it is the people's right to legislate, to be represented and to have their unalienable rights protected by the government that they create. That reading could have been correct given the exclusionary nature of the Confederate Constitution. It's difficult to square that with the Declaration, despite the fact that Jefferson Davis and the Confederacy was using it. There's a clause in the Confederate Constitution that says slavery is perpetual, and black slavery specifically is perpetual. That is incompatible with the second paragraph, so their reading is just wrong. Then what happens, and I'm going to close with this, with the Reconstruction amendments. The 13th Amendment is very clear. Darrell Miller gave you one reading, which was the losing side. The losing side did, in fact, argue that there was a right to property. They were adopting Chief Justice Taney's substantive due process argument. We don't need to adopt that argument. The side that won, the side that got our liberation from slavery passed and ratified by the states, argued for a universal right. They argued the 13th Amendment would make the promise of the Declaration a reality. And so too was their argument during the Civil Rights Act of 1866, which was instrumental in the first paragraph, first section of the 14th Amendment, which also has enforcement clauses for the protection of slavery. So I want to close with this slide about the hope of the Declaration. This slide, which shows blacks educated freely, Chinese, immigration, right there in the corner. The Charter of Freedom, I apologize, I don't think you can read this. You can't. On the very bottom, it says that the promises of the Declaration confirmed. Native Americans being able to plow. Now, it's probably got quite a paternalistic view here about them being shown a particular portion of land, when in reality was their land from the get-go. And free labor, which includes whites and blacks working from side to side. Charles Sumner, Chase, and others in the background. But what we got when the Reconstruction began to end in 1877 was white supremacy and killing and murder and a failure. The Declaration to one side, the Constitution, its reconstructed form on the other, and a failure to live up to those ideals, which, in my opinion, in my article with the Southern California Law Review, which will come out of this, were incorporated into our Constitution. Thank you.
Okay, good. For those of you trying to keep up with the program, I'm Professor Michelman. That was Professor Tsesis, who's just finished addressing us. I'm sure you've all heard of the three ghosts. And of course, I mean the ghost of the Declaration past, and the ghost of the Declaration future, and the ghost of the Declaration present. I'm going to talk about the view from the present, and I thought that, like Professor Graber this morning, I would use a currently pending Supreme Court case to help us work through some of the questions legal scholars might raise about the Declaration's present bearing on the work of the law. I imagine everyone here knows of the case of King versus Burwell, recently argued before the Supreme Court. The case is about Obamacare, the Affordable Care Act, or ACA, as I'll call it for short. The court has to decide a question about the precise legal meaning of certain sentences in that statute, where each of two different readings has respectable arguments going for it. Under one proposed reading of the statute, an immediate result would be this: whether a given American family can receive federal financial assistance for their health insurance will depend on that family's state of residence. Needy families in some states will be eligible, while equally needy families in other states will be left to manage without. That's under one possible reading, which I will call the non-uniform reading. But many lawyers would find in favor of a reading of the statute, which I'll call the uniform reading, that would avoid that odd-looking result, and the court may be closely divided over which way to go. It may surprise you when I say that none of the parties have treated this as a case of constitutional dimension. All sides agree that the legal answer depends on finding out correctly the meaning of a particular statute, the ACA, without involving the Constitution. As I will be suggesting, the legal answer could still depend in a secondary way on how we read the Constitution, but what I mainly want to ask right now is whether or how the legal answer might also in some measure depend on how we read the Declaration of Independence. Well, obviously, for that to be so, the first thing is that the Declaration would actually have to say something relevant to the case, something with which one of the competing readings of the statute makes a better fit than would its opposite. So let me just briefly suggest one way that could be so. The Declaration posits the equal natal endowment of everyone with rights to life, liberty, and the pursuit of happiness, and it furthermore proclaims the securing of these rights to be the sole purpose of any proper government. At sundry stages in our history, Americans have read those words to convey a determination that no entrant to American society should be blocked by accident of birth or family from unhindered access to the conditions of a dignified and productive life. Basic health is plainly one of those conditions, and an act of Congress contrived so as to ensure the access of some needy families to basic health services while excluding others equally needy would seem plainly, and I think I'm about to coin a phrase here, would seem plainly undeclarational under that reading of the Declaration. Such an action by Congress would contravene a principle of equality of access to basic health services regardless of private wealth or the lack of it. I will call that a principle of equal basic health care. Of course, not everyone would agree that the Declaration should be read to contain such a principle, but some readers surely would. So let us suppose for now that they have a good case. How could any of that possibly affect the Supreme Court's disposition of the King case? Had we but world enough and time, a session with the ghost of the Declaration past could easily suggest an answer. The Declaration long ago took on an iconic status in American political struggles and debates. Social movements dating at least from Jacksonian times have appealed to the Declaration in their efforts to persuade the American public toward major, inclusive, egalitarian changes in social policy. Professor Tsesis has a book that documents this history. Some of those movements have led effectively towards revisions in American basic law, sometimes by express interpretations of clauses in the Constitution, sometimes by altered judicial interpretations, sometimes by express amendments, sometimes by altered judicial interpretations of clauses already in the Constitution. And in that same way, the Declaration, as an icon of American values, could very possibly figure in a sustained social mobilization in support of an implantation of the principle of equal basic health care into American basic law. But that would all be up to the ghost of the Declaration future to decide. And my question today is more immediately anchored to the present. It's about the Declaration's bearing on the King case, now before the court. I could have put it this way. Could a lawyer preparing a brief in support of what I have called the uniform reading of the ACA find a proper legal reason to cite the Declaration in her brief? And is there any chance that her doing so would cut any ice with the Supreme Court? It seems that in order for the answer to be yes, the Declaration would have to be seen by the American legal community as a part of this country's laws, not just a part of its history and traditions. But it's not exactly clear what that might mean, and a lawyer might want to consider a number of different paths of argument by which possibly to bring the Declaration into the legal claims in King against Burwell. One of those paths would run the argument through the Constitution, That's on the right side of my slide, while two others would skip the Constitution. One path would treat the Declaration as a full-scale, duly enacted, high-ranking law in our country. Two others would be more circumspect in ways that I will explain. I've arranged the three arguments in the form of a table. I'll take them up one by one in a certain order, and I'll tell you each time which cell of the table we're in. So we start with cell 1. This argument would treat the Declaration as a full-scale, duly enacted law of the United States, and one that, like the Constitution, outranks acts of Congress. Assuming the Declaration does contain the principle of equal basic health care, the effect would be the same as if the Constitution contained a clause that read, "Congress shall make no law abridging the equality of basic health care." And an act of Congress that designedly leaves a needy family's access to health care support to depend on that family's state of residence would seem to be in violation. Such a conclusion, if you could reach it, would leave the court in the King case with two choices. The court could strike down as undeclarational any language in the ACA that would be read as calling for such a result. Alternatively, the court could use the offensiveness of such a result to the law of the Declaration as a decisive reason to adopt a reading of the ACA that avoids that result. Of course, either of those outcomes from the case would please the White House, and I expect also some of us in this room, but I believe there would be little hope of persuading present generation mainstream American lawyers to buy into cell number 1. I doubt it partly, but only partly because there's no sign I know of that either the Declaration's authors or the people looking on understood their action to be one of enactment of law for the country. And here I think I'm echoing in part some of what Professor Miller had to say this morning. So let's go on to cell number 3. I'm going to skip from 1 to 3. In cell 3, no one tries to treat the Declaration as a law that directly controls congressional action. No act of Congress can ever be held invalid just by reason of non-compatibility with anything in the Declaration. But still, the Declaration could be a law of a certain kind, and of a kind, indeed, which the historic legal tradition of the mother country of the Declaration's authors called by the very name of constitutional law. What they meant by constitutional law was not law enacted and laid down in a special document. It was rather a set of norms understood to subsist in the legal background as a matter of legal custom, norms to be used by judges as guides to the interpretation and application of statutes of Parliament when those statutes did not clearly and explicitly dictate to the contrary. An example would be the norms of fair trial for those accused of crimes. A judge who failed to insist on those norms right up to the point where an act of Parliament would explicitly contradict them would be said to act unconstitutionally. Some parts of the Magna Carta have been deemed in England to have become a part of that body of customary constitutional expectations. In the view of Cell 3, the Declaration similarly would have become a part of a corresponding American body of background legal norms against which all legislation is presumptively to be read and construed. If so, and if the Declaration contains the principle of equal basic health care, then a court that chose the non-uniform over the uniform reading of the ACA would be said, in a vintage British sense of the term, to conduct itself unconstitutionally, even if it would not be possible in American law to say that anything has occurred in violation of the document we call the Constitution of the United States. Well, of course, everything I've just been saying makes use of a specifically and peculiarly British way of using the term unconstitutional, which one would have to expect will have little or no legal resonance here. But one could make the same argument without any talk of the unconstitutionality, if anything. If the Declaration really does contain the principle of equal basic health care, And if the Declaration really is, in fact, a part of the background of American ideas against which every act of Congress or a state legislature, not to mention every rule and doctrine of the common law, is to be read and understood, then the Declaration could have a legal bearing on the King case as heard in an American court of law. Again, though, I have to doubt that a legal argument along such lines would find a receptive audience in the present-day American constitutional mainstream bar. That's something I can go into at greater length in the paper that I'll write, but I think the lawyers here probably would mainly nod in agreement. So we pass now to cell number 2. The Constitution, just as it stands, and now I mean the documentary Constitution, the Constitution of the United States, contains guarantees regarding life, liberty, equal protection, privileges of citizens of the United States. One or more of those clauses, separately or in combination, could be read to incorporate the principle of equal basic health care, thus putting pressure on the Supreme Court to prefer the uniform over the non-uniform reading of the ACA. True, there is the little fact that the Constitution has not ever so far been declared by the Supreme Court to contain such a principle, and I'm one who can really tell you about that. But that little fact, so the argument here would run, is traceable to the Supreme Court's failure so far to recognize either or both of the points that the Declaration of Independence does contain the principle and that the Declaration is a part of the interpretive background against which the Constitution supposedly has been framed and is to be read. And once the justices do recognize these points, so would run the argument in cell number 2, they will see that the ACA under the non-uniform reading would be unconstitutional in the regular American sense of that term. They would have construed the Liberty Clause or the Equality Clause or the Privileges Clause so as to make the ACA under the non-uniform reading unconstitutional. Again, though, I have to doubt that an argument along such lines would be worth the lawyer's or client's time and expense if judged strictly in terms of present legal success. In a view that has become entrenched in the American constitutional law that lawyers study and learn from books and from arguments in court, our Constitution, unlike some others in the world today, contains no guarantees respecting what the trade these days calls social rights, meaning roughly an obligation of the state to strive at all times towards assuring that people have access to the basic necessities of life, regardless of personal financial condition. Dislodgement of that view, I believe, could not occur through the kind of historical recollective argument that you see in cell number 3. It could not occur, with all respect to Mark Graber, it could not occur through deployment of the Declaration as a celebrity citation. It could only occur as a result of sustained heavy pressure from an exceptionally vigorous and widespread social movement, and I mean a movement of the proportions of the one that recently helped to transform our constitutional law in regard to the rights and status of women. In such a movement, appeals to the Declaration of Independence could play a part, but such an eventuality would lie, as I have said, within the keeping of the ghost of the Declaration future. It lies quite beyond the reach of the legal masters of the present moment. Thank you.
Next will be Professor Farber. That was Professor Michelman from Harvard Law School. And next will be Professor Farber from UC Berkeley Law School. can do this. Nope, let's see. Yeah, there we go. And here. I thought a number of the talks today allude to some themes that I'm going to be touching on too, and in particular, Professor Michelman's reference to the ghost of the Declaration past, present, and future, I think is kind of evocative. One of the themes that has come up repeatedly today involves the question of the Declaration as perhaps it might have been intended and understood in 1776 versus the way it has been understood and applied by later generations, including today. And that's also a major debate in constitutional law about the extent to which we should rely on historical interpretation versus other ways of approaching constitutional law. So I'm going to revisit that debate just a little bit and also try to come in from sort of an unusual angle to see if I can maybe shed a little extra light on the issues. There's been so much said about this in the past that I wouldn't claim to have any major new insight, but I do think maybe there's something a little bit different that I can say today. So many of these slides are really aimed at non-lawyers who might be watching this as online or here in the audience today, rather than to my fellow constitutional scholars, for which some of this at least will be quite familiar. The historical approach to interpretation says that texts have to be interpreted on the basis of the original understanding. Sometimes that's in terms of the intent of the, for example, Philadelphia Convention, sometimes in terms of the ratifier, sometimes in terms of a hypothetical reasonable reader of the time, but in any event, one that, as we heard earlier, is historically fixed. For example, whether there is a right to be free from sex discrimination under the Constitution depends entirely on how the phrase equal protection was understood after the Civil War. Another analogy that occurred to me that is in looking at an old deed. If you go back to the old days before public lands were all surveyed, you'll find deeds that say begin with the large oak where the creek turns, go 500 paces north, etc. Obviously, when we interpret that deed today, which you might have to do as part of a property dispute, we would say that what counts is the historical oak that was there when the deed was granted, not the location of whatever oak might be on the property today that is new and different. And so the idea is that construing the Constitution is very much like interpreting an old deed. In contrast to this, this comes under different names, but one might call it dynamic interpretation, says that later generations have to reinterpret the meaning of the Constitution, that the meaning of the Constitution changes over time based on historical development, values, and history. Thus, the meaning changes over time. This is the non-historically fixed, historically somewhat fluid, at least, interpretation. The Canadian Supreme Court has adopted this approach and calls it the living tree of the Constitution. For instance, people who believe in dynamic interpretation might say that the meaning of the Equal Protection Clause, the interpretation of the Equal Protection Clause, has to take into account today's understanding of equality, not just the 19th century's understanding. So
very familiar ground for the constitutional scholars or for those who simply follow the field from afar. Now, I think we can see both kinds of interpretation, and we have seen both kinds of interpretation today. For example, the question that I think Sandy Levinson first raised this morning, not the first one in history to raise, was whether the Declaration was declaring 13 colonies to be independent, or did it mean that the colonists as a collective body were independent? Did it create states, or did it create the United States? Lincoln believed that the Declaration actually created the nation of America, and that's why the Gettysburg Address says 7 years ago. 7 years ago was not the Constitution, it was the Declaration. That's a historical question that people like Jack Rakov can address better probably than the lawyers in the room. What another historical question we might ask was, what did the pursuit of happiness mean? And why was that phrase used rather than property? We typically hear about life, liberty, and property. Why did Jefferson decide on the pursuit of happiness? What did he mean by that? What did other people mean by that? And there's some very interesting work on that. I thought we might hear more of that kind of discussion today than we have. But at least some writers have linked the phrase to then contemporary Scottish philosophers like David Hume, who had taken a different view than people like John Locke about the purposes of society and government. How did Jefferson and his audience reconcile all men are created equal with slavery, if they did reconcile them? Again, a historical question that we would answer by looking back into that period of time. Another kind of historical issue, which you see sometimes in judicial opinions actually, is looking at the body of the Declaration, which nobody here has talked about, which is the very long list of grievances against the king. Some of those grievances reappear as the sort of foundation for provisions in the Constitution or the Bill of Rights. For example, the complaint about being tried across the sea makes its way into the Constitution and a requirement for a jury trial in the locality. And we might look at those kinds of connections, again looking in an originalist way to try to figure out what people might have had in mind when they wrote these particular parts of the Constitution. So I would say the Constitution is bivalent. We can think of it as a purely historical text, like, for example, Jefferson's book about Virginia. Try to figure out where he got the phrase pursuit of happiness, ask some questions about the law of nations at the time and how, given that legal structure of the time, the Declaration's legal effect would have been understood. We could ask whether the Declaration created the United States, as Lincoln thought, or 13 separate states, as the current court says. But we can also view it much differently as the symbol of our belief in liberty and equality. And as such, its relevance to our understanding of the Constitution may be greater, not because it contains particular directives, but because it embodies some dimly sensed ideals that may help influence the way we read the Constitution. So, I want to, before I get to the next slide, say that these are familiar debates. I don't have a lot to add, but I do have an interesting discussion about forms of interpretation from the modern court. Not interpretation of the Constitution, but interpretation of quite a different kind, or perhaps quite a different kind, interpretation of the meaning of public monuments. So this is a different subject, but I'm going to suggest that it's germane. So this is a case, actually, that's, I think the part about the Ten Commandments may be erroneous there, but it's a case about a monument in the park. And here's what the court said about the monument and about interpretation of monuments. And I'm going to read it because I'm not sure if people online will be able to see the slide, but it's not very long. Even when a monument features the written word, the monument may be intended to be interpreted and may in fact be interpreted by different observers in a variety of ways. The message may also be altered by the subsequent addition of other monuments in the same vicinity. The message conveyed by a monument may change over time. And I could have gone on for several more slides. There's actually quite a lengthy discussion about the dynamic meaning of public monuments, how something like the Statue of Liberty, which was supposed to stand for French-American connections and for the sort of resonance between American views of liberty and the French Revolution, instead came to stand for something very different about immigration and America, welcome to the world. Now, what's interesting, though, as you see on the last line of this slide, is that this sort of hymn of praise to dynamic interpretation was not written by Justice Stevens or Justice Brennan, for that matter. It was written by Justice Alito, joined by Justices Scalia and Thomas. In other words, this is a vision of interpretation by originalists, although interpretation on a different subject. So when I saw this, originally when the case was decided, my eyebrows went up because I thought, well, this is really interesting because everything they're saying about what interpretation means here is very different than what they say about the Constitution. I'm not saying that's inconsistent, by the way, because one can argue that these are very different acts of interpretation, but still I think it's quite interesting. So, one way that it's interesting is that one strand of argument for originalism, not the only argument, but one strand is that originalism is just what it means to do interpretation, that the only way to interpret something in an intelligible way is to interpret it on the basis of its original understanding. And to that extent, I think that there is a contradiction between the view that the court took here about the meaning of monuments and the position that some originalists have taken that meaning just doesn't mean that. You can't ever change over time. It's always got to be fixed. So to that extent, I think there is a contradiction. But I think other arguments for originalism are normative. Even if we have a choice of different ways to interpret, originalism is the best choice for one reason or another. So what I want to suggest is that I think there's a tension here that we see very clearly with the Declaration, but we can also see in the Constitution. The Constitution can be seen, like the Declaration, through the lens of history or like an old deed with an originalist interpretation. It can also be seen, however, as a monument of a kind, like the Statue of Liberty or the Declaration, a monument to American nationhood and a commitment to democracy, freedom, and equality. And I think that, at least to some extent, it is its status in the latter category as a monument that accounts for this monumental building. The California Constitution is also subject to federal law, the supreme law of California. I cannot imagine that it would ever cross the mind of anybody to want to build a public building dedicated to the California Constitution. It's a legally significant document, but it has no cultural significance at all to anybody. Nobody thinks it stands for anything grand. If they did and they spent a few minutes reading it, they would certainly be corrected. So I think that the existence of this building, the fact that people is partly a tribute to the fact that people think of the Constitution as standing for something bigger. As with the German Basic Law, it's part of what we think of as constituting us as Americans. Because we don't usually, although perhaps, as several people have argued today, we should, but we don't usually think of the Declaration as having the force of law today, we focus on its monument-like aspects, except when we put on historians' hats to worry about what people in the Revolutionary War were thinking. It's hard, I think, even though we often think of the Constitution as a text with historical meaning, I think it's hard to give up on the idea of a similar monumental rule for the Constitution. The reason is that we want the Constitution not just to be an old deed that's in our chain of titles, so to speak, that still has legal force today just because of its pedigree. We also want to think of the Constitution as something to believe in, something that stands for something, and in trying to view it from that angle, trying to view it as something that we ourselves are adopting, I think we're led to the more monument-oriented view of the Constitution, rather than just seeing it as an interesting and legally operative parchment. So, my brief conclusion is that originalists argue against dynamic interpretation of the Constitution. I think that there are important arguments there that have been developed pro and con, but what I think also is that it's probably impossible for us to give up entirely on the monumental Constitution, because doing so drives too big a wedge between popular understanding and legal analysis. Thus, I think that this internal tension in our legal practice and in our cultural practices is not likely ever to be fully resolved, and therefore the debate about originalism may never come to an end. Thank you.
Thank you, Professor Miller. We're just getting microphones. We have about 7 minutes for questions. I have plenty myself, but I want to make sure the audience has an opportunity. Yes. Please. No, go ahead. That gentleman right there.
No one has commented on simply the architecture of the Supreme Court is the most religious structure of the three branches of government, a replication of the Greek temple, and when a decision is announced, it's not unlike the anticipation that someone in ancient times went to the Oracle of Delphi.
I'm sorry. Can you repeat that question? Because we didn't get it on the live stream. Could you repeat the question to that? Thank you.
No one has pointed out that the architecture of the Supreme Court, I mean, of course, it only goes back to, I think, 1930, is the most religious architecture of all the three branches of government, and that replicating a Greek temple, and that when the Supreme Court issues a decision, even of talking about construction parallels the way people interpret Scripture, that it is that people hear decisions from the court in the same way that ancient Greeks awaited the outcome of the Oracle of Delphi, that they have this veneration and awe for the Supreme Court that you don't necessarily have for the Congress or the presidency. And so there's a subconscious religious aspect built in, however much individual justices might wish to avoid it.
I will answer very briefly, and then if we could have microphones so others can answer. I think you're absolutely right. I think that popular ability to interpret law was built into the Reconstruction amendments. The Declaration does establish the judiciary as a method of review. The Supreme Court has recently recognized it, but I agree it's too Delphic in the way that it operates.
I would just add that in terms of the architecture, Justice Brandeis always thought it looked, rather than a temple, looked like a mausoleum. And I do think actually there is something a little disturbing about the architecture of the Supreme Court in a democracy. a little bit too elevated, and a little too much of the sense that the justices are high priests descending to give us wisdom.
I would echo that thought. I guess an interesting question would be whether there's anything in the Declaration of Independence or anything in the water that they were drinking at the time they composed and adopted the Declaration, which may or may not, by the way, have been exactly the same water supply as the ones that the framers of the Constitution were drinking from. One of the things that struck me about some of the discussion this morning is that I don't think any speaker troubled to raise a question about whether the ideological background that surrounded the composition of the Declaration of Independence had remained completely steady over the 2/3 of a generation that passed between the time of the Declaration signing and the time of the Constitution's drafting. But it would be an interesting question, I think, to think about whether the attitude in regard to the Supreme Court's authority, command, ownership, as it were, of the Constitution and its meanings that does currently prevail in the United States could be connected in any way to anything about the content of the Declaration or the thought waves surrounding it. I doubt it, as I put the question, but that would be the way to connect your observation, I suppose, with the subject matter of this gathering.
Yes.
So this is, I think, primarily a question for Professor Farber and Professor Michelman, and it's based on something that Professor Miller said earlier today, which is, do either of your views in your presentations change at all or accommodate what Professor Miller was telling us, is that a majority of Americans, a significant majority, I believe it was your comment, when polled, think that language from the Declaration of Independence is actually in the Constitution. So there seems to be a major popular misunderstanding about, the source of that text, all men are created equal, and does that change either one of your takes, or does it influence either one of your takes on the role of the Declaration?
And if I may just ask for a brief answer, I apologize, so that we can get one more question in.
Well, as I expect you could tell, I was commenting on and reporting what I take from my daily experience to be the outlook of American lawyers, professionals, a professional attitude towards the relationship of the Declaration and its text and its ideas to reading the Constitution and reading statutes. Today, there could be a disconnect between the professional understanding and the popular understanding. And indeed, a perception of that kind of disconnect between professional understanding and popular understanding is part of what informs the worry that you heard in Dan Farber's remark about the deferential attitude of the American public towards the Supreme Court when it comes to working out debates about what the Constitution actually means and requires in our lives today.
I'll just add one quick sentence so we don't, I think the confusion also becomes a little more understandable when you look at the 14th Amendment and language that in fact is not really all that different than the declarations.
Yes.
So I'd like to ask this question, and it's both to Professor Michelman and Professor Farber, I think, and it has to do with the fact that you have state constitutions that in many cases include something like the Declaration's language and also have affirmative rights to education and so forth. And the question is kind of wide open, but how does your sort of analysis about the Constitution and the Declaration and the relationship, and constitutionalism change in light of the fact that you do have this marrying of positive rights that are guaranteed, plus a kind of positive sense in which the Declaration is part of the foundational document in some states.
And again, I apologize, it's a very deep, sophisticated question that I may ask just for a brief answer.
Yeah, that's a real load to try to handle in a quick response. In terms of the kinds of models that I tried very briefly to develop in my presentation, the fact that some of those state constitutions are more or less historically coeval with the Constitution of the United States, and that they did meld explicit references to natural rights into their lawmaking constitutional documents, could feed into, right, I guess it's, I think it's my third cell. That is, that the Declaration figures in the background of ideas and ideologies that historically minded constitutional interpreters, but not necessarily living constitutionalists, right, that historically minded constitutional interpreters would take that on board as a reason to license references to the Declaration by readers of the Constitution engaged in an effort to understand the original understanding of various words and sentences in that document.
Professor Farber, do you want to add anything?
I guess just briefly, I think it's always hard to know how to interpret silence, although I think you raise an interesting question. I think also, at least I would argue that the Ninth Amendment resonates with the Declaration, and although I've written a book about unenumerated rights in the Ninth Amendment, but I didn't want to sort of repeat that today. But I think it's pretty easy to see that as at least one entry point. I also wonder whether a close look at the preamble would suggest that some of the Declaration's concerns about the purposes of government are actually acknowledged indirectly there.
Thank you, Professor Farber. Thank you, Professor Michelman, and thank you for coming.
It's in the briefs. They must be in the push that was in.